First approach, the state might continue to take no action whatsoever and leave the existing speech bans in place. It would be ill-advised to do so. For many unconstitutional laws to remain in effect works real injuries against Wyoming residents. The 2010 electoral season is already upon us. Gubernatorial campaigns starting out, legislative seasons quickly fall. Maintaining the status quo ensures that an important voice here, people's voice, will be diminished or wholly silenced. And that result is unsupportable under the Wyoming Constitution, the First Amendment, and the Supreme Court's ruling in Citizens United. A second approach to reform adopts a minimalistic spirit. It aims to eradicate the constitutionally offensive sections of Wyoming's election law and goes no further. An example of this is found in former House Bill 68 from the 2010 session. Since the bill failed, I would recommend an interim approach, and that is for the Wyoming legislature to formally ask your Attorney General and your Secretary of State not to enforce the constitutionally.
Mr. Chairman, would you like me to wait till the end?
Not to enforce the constitutionally offensive sections of Wyoming election law. A third approach asks a bit more of a far-reaching question. What does the greater body of campaign finance law spell about campaign finance reform in the future? And what kind of state would Wyoming like to be with respect to free speech and competitive elections? So the latter section of my written testimony delves into other reform areas that are currently receiving attention on a nationwide basis, and that will be the subject of future litigation in other states. Examples of this include imposing registration requirements for grassroots organizations, citizens who wish to speak out about elections. That's political action committees as defined through your law. Recent litigation in Speech Now versus Federal Election Commission in the D.C. Circuit Court of Appeals is exemplary of this. Contribution limits. Wyoming stands at a paltry $1,000 per candidate per election. It's not indexed to inflation or consumer price index, and is dramatically below $2,400 federal election contribution limit.
We've been trying. Let's just hide the gold.
We've been trying.
Let me come to the conclusion here. I'll be happy to take questions.
I think the weather is affected people.
The Wyoming legislature should formally ask the Attorney General and the Secretary of State to release a binding policy that the state will not enforce portions of the state law that have been declared unconstitutional through application of Citizens United. The temporary step is important to take in the immediacy of upcoming elections and the continued chill that these laws work against would-be speakers in the state. In the upcoming legislative session, it would be urged that the legislature undertake serious reform with respect to Citizens United in much the way that House Bill 68 was laid out in the prior legislative session, and to continue to look forward prospectively about what the future of campaign finance reform holds. And ultimately, the American desire here to share your views about candidates, about political issues, should be treated not as a cause for regulation or criminalization, but as a sacred right to be exercised freely and proudly. Thank you for the honor. If you don't present these views, happy to have any discussion.